two seminar papers. We will not comment on the first one until the second one is presented. We want to take two seminar papers today. Okay? So we are starting with this one. 30 minutes. 30 minutes for the first, 30 minutes for the second. Then we can use 1 hour to discuss the two. How many of you are presenters in this paper? 4. I know that Aruna Salami is around. Yes. Tabaola Wumi Olakemi. Can you tell her to join now? If she's in a position to join, she told me, she gave me an excuse, a valid one. So please tell her to join. So that leaves you are David, isn't it? So that leaves Chinelo, Akata, Anosike, unaccounted for. She's hospitalized. She can't even join online. Huh? Did she participate in the writing? Okay. Oh yeah. Well, so all the 4 of you have been accounted for. So 30 minutes. 30 minutes. Who is going to be our timekeeper? For some time, I forget. 30 minutes, please. We want to take 2 seminar papers, 30 minutes each, then we use 1 hour to discuss. Even at that one, we will not finish until 7:30. Okay, go on.
Okay, so I'm ready to start. Good evening, Professor Echi Olaniyan. Good evening, my classmates. My name is David Ubedi, and I'm a member of the board. I am happy to present for my group, which includes Joy, Kemi, and Chine. Like the prof already said, Chinedu and Kemi, they are unavoidable assets because of ill health. So our topic of our paper is meaning and nature of conflict of laws. Our work is structured into 6 sections that examine the precise meaning of the term conflict of laws, comprising conflict of laws, local and scope of conflict of laws, as well as the dimensions in Nigeria, in order to pave the way to a better understanding of the subject. To begin with, experts in globalization tell us that we live in a global village, which is a single interconnected world where cross-border transactions take place, and when such happens, they are likely to result in civil disputes. What municipal courts have done is to evolve rules that will guide it in resolving these civil or private disputes with foreign elements. The branch of law which deals with resolving civil disputes with foreign elements is called conflict of laws. According to Groveson, almost every country in the modern world has not only its own system of municipal laws, differing materially from those of its neighbor, but also its own system of conflict of laws. But you realize that the first thing that confronts any person who is studying this subject for the first time is that the discipline has various names. depending on the textbook they are reading and where the writer is writing from. Some call it committee, others call it law of multi-state problems. Some call it intermunicipal law, private international law, private international jurisprudence, conflict of laws, etc. However, we observe that the two most popular things we find are private international law and conflict of laws. Perhaps two things account for their popularity. First, the rules of public international law are basically uniform. They cut across states. While conflict of law rules differ from country to country. Second, it's not all foreign elements that are international in nature. For example, in cases involving interstate dimensions of conflict of laws, such as in a federation with different laws operating across legal districts, such as the US, Nigeria, or Canada, you will find out that the laws are not uniform. So the rationale is that within a state with different legal districts and not across states, you cannot really say it is international law. So generally, unitary states tend to call it private international law, while federal states or federations tend to call it conflict of law. So according to Olanio, it does not matter the name you choose to call it, because the substance are civil actions throwing off foreign elements, all fall within the broad subject variously called conflict of laws or private international law. So what is conflict of law? According to Morris, conflict of laws is that part of private law of a particular country which deals with cases having a foreign element. Morris goes on to say that foreign element means a contact with some system of law other than that of the foreign court. That means you are dealing with two legal districts, and once the two or more legal districts are in contact, a foreign element is introduced. Now, succeeding scholars have tended to share similarities, barring minor variations with Morris in their definition of the subject. Professor Agbede, for instance, defines it as the department of law which comes into play whenever an issue before the court contains a foreign element. To Professor H. Olanio, conflict of law is said to arise whenever a court is asked to determine a civil dispute which throws up foreign elements. Like we earlier said, foreign elements could consist of occurrence of facts or some of them in another country. Perhaps the residence or presence of the defendant in another country. There are also judicial definitions that try to tell us the meaning of conflict of law. Lord Nichols of Birkenhead, in the case of Kuwait Airways Corporation and Iraq Airways Corporation, expanded on the meaning of conflict of law stores. I would like to quote obviously. He said, conflict of law jurisprudence is concerned essentially with the just disposal of proceedings having a foreign element. The jurisprudence is founded on the recognition that in proceedings having connections with more than one country, an issue brought before a court in one country may be more appropriately decided by reference to laws of another country, even though those laws are different from the law of the foreign court. Now, because this course, Kill 808, is entitled Comparative Conflict of Laws, what my group have tried to do is also to succinctly look at the meaning of comparative conflict of laws. Simply put, comparative conflict of laws deals with deepening our understanding of how conflict of law operates across jurisdictions. Already we have said that it's a municipal subject where each country tries to formulate its own rules to help them resolve its own element. So these rules operate across legal jurisdictions. Like we said, we live in an interconnected world, so it is imperative to examine empirical, doctrinal, or comparative methods to understand what happens in other countries. The benefit of that is that we will be able to draw lessons from what other countries are doing to see how we can improve what we already have. Also, by doing a comparative analysis, we're able to know whether we are doing well or other countries, or whether other countries will be able to benefit from what we already have here. I am very careful not to use the word international best practice, but that is exactly what I intend to see. Because if our rules are very good, other countries of the world would like to draw from what we are doing here. That's the essence of studying comparative conflict of laws. Now, what is the nature of conflict of laws? Everything that you see has a nature. Everything, every concept, every being, we all differ from each other. And so does conflict of law differ from other subject areas of law. We have identified about 6 main characteristics that gives conflict of laws its distinctive characterization. The first is conflict of laws deals only with civil cases. So what this means is that this area of law is primarily concerned with the rights and duties of individuals, which the state is not directly concerned with. For instance, property law, administration of estate, possession of movable, family law, contract, all fall under issues that may arise in characterization of conflict of law. So conflict of laws does not deal with penal issues or issues that are, criminal in nature. So the moment they start talking about criminal law, know that it is not a matter of conflict of law. Another nature that we would have examined is that conflict of laws must have a foreign element. In fact, it is the most important element of conflict of law for anyone that wants to understand conflict of law. So we call it a central feature of conflict of law for there to be a presence of foreign elements, which involves, as we said earlier, the connection to a jurisdiction other than where the case is being held. Thus, if there is no foreign element, it is not a case in conflict of law, or a case that probably will be disposed by applying the internal or domestic law to that state. Another characteristic of conflict of laws is that conflict of laws problems, they are both spatial and horizontal. For a matter to be conflict of laws, you must solve a problem that is both spatial, which will be a problem across borders, and horizontal, in the sense that the laws across the borders are both potentially applicable and equal in strength and legitimacy. For example, where parties reside in Nigeria, but the facts of the case occurred in Lome, or Ghana, or South Africa, we say that the problem is spatial. And of course, this characteristic closely relates to the foreign element characteristic. But when we say it is also horizontal, we are saying that the states have equal chance of their laws governing the dispute. Now, another characteristic is that conflict of laws is a municipal subject. The municipal subject because every country formulates conflict of law rules, and that is why there are different approaches for resolving the dispute. Unlike public international law, where states make a common law that applies to all state parties who have ratified the treaty. Now, conflict of laws, number 5, conflict of laws is not concerned with competing laws. So conflict of laws is not concerned with determining which law is superior, or the law that would resolve inconsistency between competing laws. As Professor Lanier puts it, every very common error in laws of law digest and indexes in Nigeria is the incorrect categorization of issues. For example, the issue of inconsistency, either between two legislations of the same legislature or between a federal legislation and a state legislation as it affects a case, is sometimes characterized as a conflict of law. This is misleading. This type of conflict cannot be solved by any choice of law rule. Choice of law rule employs connecting factors to determine which of the laws of two different legal systems should be applied by the court to resolve a dispute. Choice of law rules are formula for choosing a law and not for reconciling them. Professor Lanio often explains the foregoing, uses his model of vertical conflict and horizontal conflict situations. The former is based on the Kelsian essential normative hierarchy, where federal laws conflict with state laws in a pyramid-shaped structure and have to be resolved using covering the field formula, which you all know to be section 4 sub 5 of the Constitution, to determine the question of superiority. So conflict of laws is concerned with only horizontal conflict situation, which deals with facts and not laws. In fact, conflict of laws instead focuses on identifying factual factors which determine the most appropriate law to govern the dispute with foreign elements, while respecting the sovereignty and validity of other different legal systems. Now, the sixth characterization is that conflict of laws is always concerned, particularly in common law jurisdiction, with three big questions: choice of jurisdiction, choice of law, recognition, and enforcement of foreign judgments. I'll briefly speak to this. For choice of jurisdiction, this relates to the question which court should the claimant approach if the case has a foreign element. Which of the foreign courts can rightly entertain the matter? So this is about the forum. What matters substantially and procedurally within the competence of the court is that rules that govern jurisdictions determine which jurisdiction to approach. Choice of law. This relates to the ascertainment of the applicable law after jurisdiction has been assumed by the foreign court. It is a function of private international law to ascertain which of the several potential laws must be chosen for the determination of an issue. It's necessary that the forum applies its local laws to the dispute. When foreign law is applicable, then it becomes a question of facts to be proven. So the various formula which apply with respect to family law, contract law, succession, property law are usually called connecting factors. Recognition and enforcement of foreign judgments. This question arises distinct from the other two that we have discussed. Now, recognition deals with the foreign court recognizing a foreign judgment. For instance, judgments relating to status, let's say divorce or bankruptcy. A good illustration of recognition of foreign judgment is cases of limping marriage. That is a marriage that has been dissolved in one country but may be valid in another country. For instance, if a Nigerian couple obtains a divorce decree in Togo, it is not recognized in Nigeria unless and until a Nigerian court recognizes it. The Nigerian law will regard the marriage as still subsisting, and parties will be prohibited from remarrying since Nigerian law prohibits bigamy. Thus, once foreign judgment is recognized by a foreign court, the status of the couple will change from married to divorced, thereby giving the parties the authority to remarry and enjoy the benefits of the judgment. Other than mere recognition of judgment, there is need for enforcement of foreign judgment, especially in cases of monetary judgments. That is where one has to enforce a judgment debt. So that is that for recognition and enforcement of foreign judgment. We also examine the various dimensions of conflict of laws. Succinctly put, this refers to the various levels in which the foreign court encounters conflict of law problems. Nigerian conflict of law, Nigerian courts encounter conflict of laws at three main levels: the international level, interstate level, and at the internal or interpersonal law level. At the international level, the foreign court is called upon to determine a civil dispute that has some factual connection with another sovereign country. This is straightforward. Basically, it's a situation where the foreign elements involve two sovereign states or four sovereign states. Now, at the interstate level, the conflict of law arises when one state, where the component unit of the state have some level of autonomous legislative competence or legal districts, which are concerned with foreign orders. Interstate conflict of laws common federations like Nigeria, Canada, the United States. Thus, the court in Babcock and Johnson said that in many federations like Nigeria, where states have the power to make laws, the issue of which of the state's law is applicable is likely to arise. So this is what we call interstate conflict of law in a nutshell. We also have internal conflict or legal pluralism. So legal pluralism, to begin with, has nothing to do with multiplicity of sources, as is commonly found in legal system testing. So it is not that laws in a particular legal system, from constitution, receive English law, customary law, Islamic law, judicial precedent, international law, whether customary or treaty. That is not what legal pluralism is concerned about. Legal pluralism has all the basic features of the other dimensions of conflict of law, except for elements. Legal pluralism rather has it refers to a situation where a legal district permits two or more systems of law to operate on a particular subject of law, but not on all subjects of law. For example, marriage, where a person can either marry under the Act and is no longer amenable to other options such as customary law marriage. Comparatively, in the UK, there is no legal pluralism in the subject of marriage. So the only marriage it recognizes is monogamous marriage. Now, there are three main questions that may arise in legal pluralism. The first is, what is the test of amenability to systems of law? This answers the question, what is the formula for determining who is governed by a particular system of laws? The second question is, what formula governs amenability to change? This means, is there a formula for accepting that a change has occurred and that the act of the defendant has now made him amenable to another system of law? That's basically dealing with the test for amenability for change. Now, the third test is which of the system of personal laws apply to two persons governed by two different personal law systems. For instance, if a marriage takes place between a Christian A and a Muslim B. So we find that personal law, basically, is the law of that territory or race or religion with which a person is permanently connected with and which determines the status of family relations. So there are three main bases for personal law systems: territory, race, and religion. Now we conclude this paper by saying that at the heart of conflict of laws is the fact that private transactions must involve foreign elements. We looked at 6 characteristics, features of conflict of laws. And we also found that in common law jurisdiction, conflict of law generally involves 3 questions: choice of jurisdiction, choice of law, and recognition and enforcement of foreign judgments. Now, we have gone to make a few recommendations. Of course, the paper is not complete without recommendations. So we recommended that conflict of laws should form a part of the Nigerian Bar Association's mandatory continuing legal education program to enhance the knowledge base of lawyers about the nuances of the discipline, which is often misconstrued, even by judges. We also recommended that there should be judicial training amongst judges to enhance their competence to handle complex issues dealing with conflict of law. Also, of course, think that operating study of this discipline is very important, as we are doing here, to enable us to incorporate what is often called international best practice. And with that, that is our paper. Thank you very much.
Yes. That's the first paper. Let's take the second one so that we can discuss the two together. They didn't spend 30 minutes. They didn't spend up to 30 minutes. So the presenters of the next paper, we just copy them and not spend up to 30 minutes. So that whatever we have left will be enough to discuss the two papers. So who are the presenters of the second paper? They are not even here. Have they submitted? Wow. Where are we going to finish? Your exam is already slated for a big margin. or when? So it's only one paper we need to take today. And the presenters of the second paper are here. Group 2. They are not here. But have they submitted? I thought I saw their paper. I think they are talking about sources. They are supposed to discuss the sources of the rules of conflict of laws in Nigeria. That's what the second paper is all about. Okay. What is the third paper all about? Is anybody here? Well, I know that the third papers too, they have submitted. So we are going to take only one paper. We are becoming very unserious. Don't you think that we should go back to our online method? Because if we are taking one, we will not finish. If I had known that this is where it's going to be, I would just feel that the way we teach the students. The topics will be very few, but for example, they can conveniently take their introduction together with sources. So instead of calling on some people to come and take that one again. So we go ahead to discuss the first paper. There is really not much in the first paper, is there? So anybody who knows about this subject previously, what they have said is just the gospel truth. And it's basic knowledge that we need to have. But let me see whether there are people who will take them up on anything they have said. Is there any comment? Is there any critique? Is there any question for them? They've made it precise, but there is nothing they ought to say that they have not said. Any question, any comment? Yes. Let's say in the whole like US, the black person has you have the system of family. Don't give it this name, right? You have one person out. You can get this. You keep them from another person, maybe this extra mobility in another area. Just the connecting factor. What connects? When we are looking at the movie, where you know, so the first thing we talk about is right. Okay, so as a more let me help you. You see, you want to understand the grammar and the student of personal and non-personal system. You have to give it to our own Professor Abede. Go and read, I think, chapter 12 or so of his book, Legal Pluralism. He explained what we mean by system of law and what we mean by personal law. Okay? Now, the group of subject areas that we call personal law are subjects governing areas that are personal to the individual. Okay? Okay? Every country, their law must regulate that area. So when we talk about areas like marriage, custody, matrimonial custody, succession, legitimacy, legitimation. Okay? All of these areas are areas where virtually every municipal system before personal status area. Okay? So we say that personal law is territorial. What do we mean by that? What we mean is that ordinarily you would have to be attached to a particular territory for us to determine your personal law. So when you get to presenting papers to us on the topic we call domicile, nationality, and are the three different tests across the globe that countries use to identify which personal law they will apply the person. In most common law, so they will say that when they find you, in the area of personal law, that they will use determining the law, country's law that they will apply to the On the other hand, you find some countries that use nationality. They will say that when you become a party to litigation, your personal law in their own country, in order for them to determine which law they will apply to, then solve. So, if, for example, when we work we are referring to the imaginary person whose personal law is a issue. So if the propositor, for example, is before Nigerian court, and of United Kingdom, Nigeria uses domicile as our own connecting factor. So Nigeria court might apply to answer all affecting in those areas. Legitimacy, but all the factors are falling in that area. So Professor Agbede explained that personal law is territorial. You have to be allowed to be one particular territory. And because conflict of law is a principal object, you are not rest assured that any court of the world that you go there, every country will have a That's why common law country civil law country will use nationality. Some countries they are ready to apply but it is territorial. Because it's territorial is the reason why it must connect with the particular territory more than the aspect of the dimension of conflict that I was talking about He was talking about what we call legal plurality or internal conflict, internal systems of law. And he said that everything about conflict is there is no problem. What do we mean by that? If within the same legal district, you have a choice. Which system of law will cover you? Obviously, the reason why conflict of law is involved in matter of arbitration before the end. Because you and your are both connected with that system. But once you remove the issue of tenancy, every other thing about conflict is here because you have chosen to be amended to one personal system of which allowed, and another person. That's why we see that. That's why when very easy to manage. You may all be governed equally. We may all be subject equally to the same thing, but not be governed by the same marriage law. A may choose because our law allows to be governed by the manager. He might be in the car. He might be in the car. Neither is less legal than the other. What has happened is that our legal system permits both. So when you have a situation where on the same subject matter, you have more than one system of law, then you say that in that legal district, there's a legal pluralism. Okay? There's a legal pluralism. And the questions that were raised is what he has mentioned. So if there's a legal pluralism on the subject matter, how do you determine who is amenable to one system of law as opposed to the other? Now, where the issue of race came in is this, that generally across the globe, the known three bases for allowing personal system are religion. You have some religion that also have a legal code. And it's almost always impossible to say you permit the person while denying the legal code of the religion. So religion can then become a basis of identifying personal system of law. Ethnicity in multi-ethnic society, where the legislature has not chosen to cancel ethnicity as a basis of differentiation between people, then the legislature must have to condone different rules for doing the same thing. So ethnicity, and that is the one we have in Nigeria, when you have ethnic customary law differentiating between persons. A basic test in legal system will tell you there are two bases of difference between ethnic customary law and the general law, and between system of ethnic customary law. All of these are products of legal pluralism. Then race. Race is possible in societies like defunct pre-independent or pre-whatever South Africa. Yeah, in apartheid South Africa. Race clearly was the basis of representation, as you would then have different laws governing people with different colors of skin. So that is how race can be a basis. You know, that is, today, nobody is proud to say that race is the basis of differentiation of people in this country. Okay? But we have seen in the past legal systems that have projected it openly that in this country there are some laws that will govern Black, which will not apply to colored people. So that is why we use race. Okay? Of course, in Nigeria, race cannot be a basis because there is not a second race. There is a second race. I think we are all Black. The other color we have is albino. Apart from Black, the only other color we have is albino. Yes, you will say it's light, it's just light, or it's still black. So race cannot really be a basis. But in the global discussion of the topic, we use race also to explain basis upon which we may have pluralism or internal conflict in the legal system. Is it clear?
When you want to buy it, you must pay the money. You don't have that.
Most African countries have legal pluralism on the basis of ethnicity. Nigeria is not the only one. If you look at the structure of the legal system of most African countries, especially those that have been subject of colonization by the Europeans, in the bid to preserve their ethnicity, the colonial masters allowed pluralism. So once you allow that, ethnicity then becomes a basis of pluralism in most of the African. Okay? And the pluralism will be, you can broadly categorize the citizens into those who would rather be governed by the general law as against those who will be governed by their ethnic customary law. That's one basis. Another basis is once you regard ethnic customary law as the basis of differentiation between people, then you must operate a pluralism. Because, like you said now, a certain tribe in South Africa, the Zulus, will not marry the same way as so if you recognize it, then you have recognized pluralism. Okay? Any other questions or comments? No comments? Okay, let me ask you a question. If you have read their paper, they talked about the different names that this subject has been given. And somebody who did not participate in the paper, tell us the different names and the reasons for the different names. I know that most of you are just going through the paper now. Okay, the paper is very explicit about the different names. The only thing I want to add is that the most common name that you give to the subject, where you are talking to it against the background of the legal district that it is a federation, is conflict of laws. And the reason why you give it that name is because that term, conflict of law, is then able to cover all the dimensions. Okay? What are the dimensions? In the federation, you must have a minimum of 2 dimensions. The first one is private international law, in which case the foreign element or the out-of-state connection that you are talking about is a contact with another state as recognized in international law. So you easily identify that it's private international law if passengers who took off from Kumasi, Ghana, heading to Nigeria, had an accident in Benin's territory, Benin Republic territory. So you see that, so this is not an issue that will be completely resolved by the Nigerian law. If the matter were to come before the Lagos High Court, for example, must quickly recognize that this matter has foreign element. And what is the foreign element? The foreign element is a contact or connection with either the Republic or Ghana. 2 states known to international law as when you talk about horizon. In international law, when the matter has connection with Ghana or the Republic of Nigeria, there is an horizon. Okay? You're not looking at the size of one of the 3 contacts, but the fact that international law treats it as distinct legal district. That's what we mean by the facts is horizontal. So a Lagos High Court judge determining liability for that accident must not forget that he has to be sure whether it is the Nigerian law that will apply because it comes to Nigeria, or whether it is Beninese law that will apply because the accident of the government, or whether it is Ghanaian law that will apply because the party took off from Ghana. So that's private international law. On the other hand, you can have the accident in Lagos, and the accident could have occurred at Ogeri in Ogun State, while the party took off from Ibadan in Oyo State. Okay? Again, there is another dimension of conflict of law there. So you have to be sure whether it is Lagos law that it will apply because the court is in Lagos, or it is Ogun law that will apply because the accident occurred in Ogun State, or Oyo's law that will apply because the parties took off from Oyo State. Okay? So that second dimension is called interstate conflict. So the reason why the subject will not be called private international law in the federation is that private international law will only be able to govern the first dimension, which is connection with the Republic of Ghana. Okay? So in the federation, each constituent state of a federation is treated to the extent that it has its own legislative competence, it is treated as a separate legal district. And so every of the issues that you have when the fact of a case has connection with another state of the world, you can also have when it has connection with another constituent state of the federation. So that's why the term conflict of laws is preferred if you are studying the subject in the context of the federation. But if you are studying it in the context of a unitary state, the only dimension of conflict that you will think of, apart from the internal one, is a connection with another country of the world. And so the word private international law is more suitable. And the term private international law itself, when you analyze it, it is international law or it is private. It is international law or it is private. It could be very misleading. Many text writers will take their time to explain to you why the use of the word international law can be very misleading. My own way of putting it is that in private international law, what is international is the fact. What is international is the fact and the scenario. As far as the norm is concerned, the norm is municipal. And so, you are then able to distinguish between what we call private and public international law. Okay? In the case of public international law, the subjects of public international law are states and to some extent international organizations. Although those who are experts in the area will tell you now that because of concerns for human rights and all of those things, it is becoming more and more blurry, the distinction between municipal law and international law and all of that. But it's very clear that you have a distinct international legal order from a municipal legal order. So when you are talking about public international law, you are talking about norms at the international level that is binding, that is uniform, wherever you go. But because the only thing that is international about this subject is the fact and the scenario, you still look onto municipal law of one or the other country that is connected with the matter for solution. So that is why it is possible for Nigeria to be using domicile and for the Republic to be using nationality. It's because the subject is basically the municipal law subject. Okay? I think it is Professor Agbeden that said that in a way, private international law might very well be an addendum on every subject of law that you have studied under your municipal. If it has that design, you can measure that way, but as well as learned when your teacher taught you contract, they are taught you the Nigerian law of contracts, ignoring when the other party or when the facts throws off connection with another country. So, for you to have a complete picture, you might as well have ended the discussion on Nigerian law of contracts without further elements. Then go to Nigerian law of contracts when there is further element, in which event we will now be telling you, okay, oh, this contract, this offer and acceptance thing we are talking about, assuming the offer is between somebody in Ghana and somebody in Nigeria, what happens? Okay? Assuming the contract is breached, where will the parties litigate? Okay? But you find that that is not usually done. And so, a separate subject area known as private international law exists in every country's legal curriculum. Okay? So, that is why, even though it is called international law, the norm are municipal law norms. Every country will come up with its own, but what is uniform is the problem they are trying to solve, which is foreign element or connection with another legal issue. Then the word private, of course, we all know what it means. That it is private simply means this subject area has nothing to do with anything. They said it. That has nothing to do with anything criminal or public. So, and that's why some of the time the subject might just crop up without anybody preparing for it. It may soon be. There is nothing that says they cannot do it. But when the facts come into the open that, oh, he's talking about the contract that was done in a foreign territory, or he's talking about a contract where the parties have agreed that the governing law to the law of a foreign country, then the foreign element becomes very clear. And this subject area, the knowledge of this subject area, and specifically the knowledge of our own rules, of Nigeria's own rules to govern this subject area, will then become necessary. Then he was trying to explain the term comparative conflict of laws. What does it mean? I would agree that the rules of this subject area are municipal law rules, but that because they are municipal law rules, countries need not adopt the same rules. So what we are comparing, when we say comparative conflict of laws, what we are comparing are the different approaches of different countries to the foreign elements. So it is under comparative conflict of laws, for example, that we know that whereas one country will use domicile to determine connective factor, another country will use nationality. Okay? If you are confining yourself to just Nigerian conflict of laws, it will be enough to tell you that under our own rule, we use domicile. Okay? But because the class is a comparative class, we want to see our own approach is to use domicile in that area. But we have countries that use nationality. We want to compare. We want to see which is better. Okay? Or which is easier to apply, which is more just than the other, and all of that. That is what a comparative conflict of law class would do. Okay? I think the next other thing you need is, what are the usual questions? And they have answered it for you here. When we say a matter requires knowledge of the country's private international law rule, the matter must have thrown up any of three questions. Any of three questions. The first one, choice of jurisdiction. Choice of jurisdiction. What do you mean by choice of jurisdiction? The example I gave you, they took off from Ghana, had an accident in the Republic. Because they were headed to Nigeria, action is instituted here in Nigeria. A Nigerian court must examine Nigerian law to see whether in the circumstances it could entertain the matter. So in the same way, a lawyer who is consulted to seek relief must be familiar enough with Nigerian choice of judicial rule as to determine whether a Nigerian court will be able to entertain the matter or not. Okay? On the other hand, if the litigant prefers that the action to be instituted in either in the Republic or Ghana, then the person who is consulted must have knowledge of the Republic or Ghanaian rules of choice of jurisdiction in order to determine Am I right to go to Ghana, or am I right to come to the Republic, or am I right to go on in Nigeria? So that's question of choice of jurisdiction. Okay? Then there is the other question, the question of choice of law. This is the one that those who do not know the subject area, they don't usually appreciate. We lawyers, we like using the word jurisdiction to cover everything. For example, if a Nigerian court looking at Nigerian choice of judicial rule comes up with the answer that yes, we can entertain the matter, notwithstanding that it has connection with a foreign state. There are so many cases where such decisions have been put up by enlightened courts. You will find cases where somebody is saying that the court does not have jurisdiction because the fact occurred elsewhere. Okay, there is this very popular case. I don't know. I'm getting old. I keep forgetting things. It has to do with it's an action against, I think, an Israeli diplomat. Zabuski, yes, Zabuski's case. So when the Israeli challenged the jurisdiction of the Lagos court on the basis that this is basically a matter relating to the defamation of an Israeli, why should the Lagos court be handling it? Of course, the court was aware of the relevant Nigerian choice of judicial rule in the matter. The relevant Nigerian choice of judicial rule in the matter was Section 10 of the High Court Law of Lagos. That's a concern. And that section simply says that in that type of situation, Nigerian court will do as the English court could do. And what would the English court do? The English court will apply what is known as the writ rule in a personal matter. That if it is possible to serve you our writ within our territory, then we have jurisdiction over the matter. That's the answer that the High Court and the Court of Appeal gave in the matter. So what they have done is to apply Nigerian choice of judicial rule to answer the question whether they had jurisdiction or not. Okay? Now, the second question is choice of law. Those who are not familiar with this subject area would then think that the moment the court has assumed jurisdiction, it must apply Nigerian law. That is not correct. That is why you have the second and third leg of questions to be answered. The second leg is choice of law. That is, these people now haven't allowed the case to go on here because of the sworn element. I will not decide it the same way I will decide a case between Abiola and Dosu, who have the part of which began and ended with Nigeria. I must take note of the foreign element. So the choice of law rule is our own rules that direct our own court on which law to apply when the case has foreign element. It is not the same as our choice of judicial rule. And so the fact that our choice of judicial rule has directed us to entertain the matter does not mean that we must apply our law. So for most people who are not familiar with this subject area, they will mix up those two questions. They will mix those two questions up. And they will answer the two questions with one answer. Either the answer for law or the answer for jurisdiction. Okay? Either the answer for law or the answer for jurisdiction. Okay, as we progress, we'll be pointing out where the Nigerian courts have mixed the two questions up. And that's use the answer for one as the answer for second. Okay? So, and then the third question that could arise. It may or may not arise, but it could arise where instead of the litigant coming to Nigeria to sue, they are sued in Ghana and they have obtained judgment. But if the judgment debtors' assets are here in Nigeria, okay, what they have done is that they have behaved like somebody who is coming from Kano and traveled by train. Definitely, he has a second journey to do because there is no way who is coming from Kano to Ijebu for and he traveled by train. Okay, definitely he has two journeys. He has a rail journey and a road journey to undertake. So if he stops in Lagos or Abeokuta, he will still have to. So the man who either because Nigerian courts, the rules of Nigerian jurisdiction would not permit Nigeria to entertain the case, had gone to Ghana. But the judgment debtor is asking, definitely, he has to come to Nigeria to do something again. What does he do? He will ask Nigeria to recognize that judgment he has obtained in Ghana and help him enforce it. So that's the third question. Recognition and enforcement. Okay? Did you distinguish between recognition and enforcement? Okay? Anyway, we will have opportunity to do that in more detail. But the basic distinction between them is sometimes the foreign judgment you obtain is a status judgment. For example, if you got a Ghanaian court to give a decree of divorce or to nullify your marriage with someone, okay? What do you need when you come to Nigeria? All you need is for Nigeria to accept your new status as somebody who is qualified to remarry in Nigeria. So that you want to go to the registry at the Ikoyi with another person, and somebody does not come and say, look, she's still married, though. She's still married. Her marriage is governed by Ghanaian law and has not been dissolved. If Nigeria will recognize the decree of nullity or divorce that you obtain in Ghana, that is enough for you. Okay? But assuming the Ghanaian court had gone ahead to make order regarding payment of money, then you need more than mere recognition. You need enforcement. Assuming the other spouse has his assets in Nigeria, has his bank accounts in Nigeria, you will not bring a judgment from Ghana and tell the bank on the basis of it, or garnishing those bank accounts in Nigeria on the basis of that judgment. You will need the Nigerian court you need assistance of the Nigerian court to enforce that judgment. So that's why that becomes a third question that could arise when cases have foreign element. Okay? I think that's all that we told them to do. We have understood the dimension now. The international, the interstate, and legal pluralism or internal. Basically, the internal simply differs from interstate and international because really there is no foreign element. But because the legal district itself permits more than one system of law in the subject area, then other issues could arise. Other issues could arise as how do you determine who is amenable to which system? Okay? How do you identify when there has been a change? Look at the celebrated case of Olowu Adolowu. The man was Ijesha, but he lived in Benin. And so distribution of his estate, members of the family, some wanted the new customary law to govern, others want the customary law to govern. Okay? So you have the question. Is it possible for somebody who would ordinarily be amenable to a customary law to become amenable to the customary law? Okay? Adesiboka and Yunusa, the man was from Umwana, but he had lived in Lagos. And one of his counsel submission was that he should be governed by the customary law of Yoruba people living in Lagos. So the question is, if he was from Umwana, which is territorially part of northern Nigeria, is there a possibility for him to become a minister? Okay? So those are the type of questions that would arise under legal pluralism. The third one is, since the legal district itself permits people to be amenable to different systems, there will be transaction between people who belong to different systems. And the example of a person who, by our rules of pluralism, is amenable to one customary law, entering into a marital relationship with a person who is either amenable to another customary law or to Islamic law. All these are questions that will also arise under legal pluralism. Okay? So I don't know of any other thing said that we have not explained. So, because the second paper was not presented, we will go before the end of the class, yes? Yes. Yes. No. That's not what it said. There are two different issues. I teach that to my legal method students. Okay? You see, that's what you call normative hierarchy principle. You use normative hierarchy principle in all systems of law. That is, you assume that the two are norms, but one is superior to the other. For example, when you take section 475 of the Constitution, what is basically done to recognize state law enacted on other something with the concurrent basis that is properly done, and federal law enacted on that subject that is properly done. But give a formula of superiority. What is that formula? That if they are both valid means on the same subject matter, the federal law. Understand? Do you understand that? So that is the application of the normative hierarchy principle. You do not apply normative hierarchy principle when you are talking about whether Nigerian courts will apply Nigerian law or should apply the English law to an aspect. You are not thereby implying that one is superior to the other. Okay? So in the court debate from my laptop, I was trying to look at, if you check most of our indexes, and you are a person who is doing a blindfold research in this subject area, the conflict of laws, section so of federal law, these are the section so of state laws. That's not conflict of laws, strictly speaking. Because if the only way you will resolve it is to use a normative hierarchy test, or to say that, oh, by virtue of the Constitution, this one is superior to this one, that's not conflict of law. And that's why we use the term, we said it must be spatial and horizontal. Okay? It could be a type of conflict that is vertical, not horizontal. What do you mean by horizontal? you are choosing between Nigerian law or Beninese law or Ghanaian law or rising. They are all on the same level. So the conflict is horizontal. But if you are talking about the same Lagos, and you are looking at the Lagos law applicable and the federal law applicable in Lagos, that's vertical. Do you understand why I use the word horizontal as opposed to vertical? It is vertical when you are saying that both of them are norms applicable in the same legal duty, but one is superior to the other. But it is horizontal when you are saying that this is the norm applicable in state A, that is the norm applicable in state B. And the real reason why you are picking that of state B or state A is a different formula known as choice of law. Then when we get to that stage, people will tell us how you arrive at the less consider, the applicable foreign law. It is not any formula of superiority. Do you understand? So that's what we mean when we say, no. You call them conflicts, but strictly speaking, they are not conflicts of law. The two statutes of the same legislature, if they conflict, that's not conflict of laws. You use interpretation of statute. Either you say the one that conflicts, presumption, getting later one, canceling the earlier one, and things like that, or you have the constitutional provision that already directs you on how to do it. Whatever one you are doing, one is canceling out the other. But in a typical choice of law rule issue, no one is canceling the other one. You are just saying that in the context of the facts, this is the one that I will apply. Is it clear? Yes. Any other question? So, please, next week we will paper. We can't be doing master paper. We will not finish it. So, yes. There is no reason why we won't do 3. So I see you next week. Who gave me this? Yeah. How are you? She told me. How are you? She also told me that you did that. You are doing can you read the letter? Go and write it and send it to me. So that yes. Send it to me so that I will follow up. They have not started doing it.
Yes, we've not started. All right, so I'll do that.
Yeah.
All right, thank you very much.
Yeah, welcome. So this is what we said. Who called you? Let me explain it to you. I think mobile include one of the subjects, or bóyá tó dẹ̀ send sí mi ò correct. Òun fúnra rẹ̀ ló send the after they check for him. Cost there. So forward sí mi. Law of International Institution, first semester, second semester gbogbo ẹ̀ ní so onímọ̀
Okay, levy
onímọ̀
calculate.
àdìyí sí 2 plus 4 plus 2 plus 1 plus 1 plus 0. This one eléyìí la change. So mo ní plus 2 then plus 0 then àwọn mẹ́rin ti ọdún yìí plus 4 plus 4 plus 4 plus 2. So when you add all this, it gives you 26. You multiply by 3, it gives you 78. Meanwhile, this is
Project.
it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 times 3 units. That's 36. So that means this 78 is over 36. So design project per unit.
40.
So no, 5 times 4 get 20. So when you add the 20 to 78, it gives you 98. When you add the 4 to the 36, it gives you 40. 19 over 40 is 2.45. Okay, what you are lower by. So unless one of these subjects was not important, or this
40 náà ló pè unit o.
40 ni tó bá ti effect eléyìí tó jẹ́ wá yẹn sí 2 tẹ́lẹ̀. Problem. Or maybe one of the courses. Maybe he was wrong in what he said is called in one of the courses. I don't think he was wrong. I'm sure he was correct with this one.
Send it to platform.
So, can't hold that. How are you?
Okay.
Mo ti sẹ́ láti mọ́ gbé wá ìlú. Màá tẹ̀lé ọmọ tó fẹ́ ṣe postgraduate diploma in procurement ni. Màá sẹ́ndì ẹ̀ka wo any follow up tá a bá lè ṣe. Okay. Okay, no. Thank you. Who is that? One. Oh, don't say.
Bàbá, nígbà tí a bá lóde òsì bóyá ìtẹ̀ kó tuntun lè máa wà. Kò sáṣọ kan pàṣẹ òbí ilé ìdìbò ẹ̀ tán lè máa.
Mi ò gbọ́ bí tí mo ti rí kò ságbádá mẹ́ o.
Bí àwọn kò dẹ̀ sẹ́gbẹ̀ẹ́ ní omi ṣáà ẹ̀kọ́ tì. Ó ṣe kúkú báyìí sí. Ẹ tó tán náà. Ẹ tó kí ni ọjà lé kó má ṣe kú ẹ léṣe. Ṣé wọ́n lórí owó? Omi ẹ fóònù kan gbóná. Nígbà yẹn ni. Òfin pípa yìí ṣe. Pípẹ́ tí kan tí mo rà ní. Pẹ̀lú wàhálà wà ní sígbà. Ó ṣà ń ṣe bó ṣe wù ú.
Ọtí ìlú fóònù ẹjọ́ náà.
Ó ti náà sọ̀rọ̀ lọ́sẹ̀. Di lọ́dọ̀ àwọn òṣèlú méjèèjì ìyẹn pọ̀ tó pàṣẹ dání. Gbogbo ìgbà tó ní ẹ̀sẹ̀ yẹn. Òun ló ní ọ̀sẹ̀ tó ní. Ó pè mí. Making small movements to one and two. You know, what we share out to one
Let me start when longer. Longer. Give me water. Yes. Yes. Time to again them. If food is ready. Monday morning, time to again. If food is ready. Don't have. So the borrow the ticket ẹnìkan lò ní ọ 2 million. Samuel. Dọ́kítà lèmi náà. Bẹ́ẹ̀.
financial regulation. Yes, what it is.
Okay. Oh, okay, well, I'm not just saying.
Oh, I think it's a shame. Oh, but I was-
Ǹjẹ́ wàá pẹ́ àbíkù mọ́? Àwọn òbí wẹ́dà bọ̀dà wo ni ó lọ pamọ́ lẹ́ẹ̀kan?
It doesn't balance.
Wọ́n ní plate number òun. Mo dẹ̀ ń bí tán sọ pé ká má máa mú ìyàwó rú nǹkan báyẹn.
Let's get something said.
Àwọn ní kí n bóun pé ọmọ ìlúwa tó wà ń tẹ̀. Bàbá yìí rẹ̀ tún mú òǹdè mi lọ, classmate tiẹ̀ nìyà. Ẹlẹ́ ẹ̀dá. Fídíò ni wàá lò. Ó ti kọjá rẹ̀. Can't connect right now. TMU. Let me see.
Yeah, it's big. Look at the bed you see, see. Is it-
That mean, okay, on the other bed.
You're Jeremiah.
Second.
Mommy, I'm sitting on that Jeremiah. I sit on that.
If you have been fired,
No, they are here. They are still in here. Where do you keep them? Big one. Big one. Oh, they didn't even put the bed in here.
no, I'm really looking back to-
It's the- Express. This is the express, right? Yeah. Oh. That said, I won't just one for two slices. Therefore, you need to cover it. Okay, I'm sorry, okay. What is she?
Ọlọ́run ló dájú náà máa lè fún wọn gbà. No, wà kíláàsì lẹ́nu ìgbà.
Wọ́n mi gan ní wọ́n mi ìgbà tó pè mí láàárọ̀ wọ́n ní àwọn oníkí ayàbọ̀ dúró kọ́ báwọn tiẹ̀ ṣe lé ẹjọ́ mélòó pẹ́. Mú ní àwọn wọ́n wáyé ìwà bá yín ṣeré. Ó ní kí n fi lówó mọ́tò kẹwàá o kẹwàá báwọn ṣeré. Yeah. Ẹ̀tọ́ nìyẹn máa ṣe. Ìyá ní ìyá tí ẹ̀kọ́ ti lọ gbé sí wọ́n kọ́ lọ gbé yẹn sí ìgbéga. Ìyá dẹja kò dé. Ó sì di kò dé. Ìgbé èyí ṣe gbogbo wọn tó ń sùkú yẹn tó bá yà dẹ̀ mọ̀ lójọ́ tẹ́lẹ̀. Ìyá ní ìyá tó wọn máa fi gbogbo òṣù káàkiri. Wọ́n lòun ṣeré ká. Padà. Yes.
PPP. Ochoku. Opposite.